Hopefully I'll get them as soon as practicable. I want to talk for a brief moment on how I want to do the exam reviews, because the answer is a little bit tricky. By way of background, in years past, I would require every student to meet with me in person. It was not easy. I would usually get to the law school on Saturday and stay from 9 a.m. till 9 p.m. And then I would come on Sunday and do 9 a.m. to 9 p.m. It would take me like 3 or 4 weekends to do that. It was very time consuming. What also made it problematic is that students, as you might imagine, did not keep their appointments. So let's say you had a 9 a.m. appointment and then you show up at 11. And the person at 11 shows up at 1. And then just would sort of back up, right? So the entire day was basically burned by the time I got to 9 p.m. People were there till 10 or 11 o'clock at night, which is not ideal. So I stopped doing it because I thought it was not a good use of my time and anyone else's time. This semester I'd like to do something similar, although using Zoom. Obviously, we can't meet in person. We're not allowed to. It's illegal or something like that. So I'd like to meet with all of you electronically, at least one time through the semester. What I'm thinking about doing, and I haven't quite set on the logistics yet, is having a series of open hours on evenings and weekends. I don't want it to be during the day because you all have class and you have office hours for other classes and people aren't going to come by. My hope is that if I leave certain hours on evenings and weekends, then people can come by when they want. You won't have to make a reservation because I think those are not kept anyway, so it's not a very good use of time. And there'll be a queue. And Zoom automatically sorts people based on the time they enter the queue. So I'll call on you when you're ready. And if I call on you and you're not there, I'll put you back in the queue. You can come back in later. Say, hey, John, you here? If not, I'll give you a minute and I'll go to the next person. This, I think, would allow me to see the most number of people without wasting everyone's time and without wasting my own time. I've not settled on this, and if you want to raise your hand, please, I welcome your thoughts. But there's no good way of doing appointment slots on Zoom because people don't keep their appointments. If you recognize that, you realize why it won't work. Because I'll just be sitting here looking at an empty screen for 5 minutes. I've tried it and it doesn't work. So if you have any thoughts, please, I'm happy to hear them. Lainey asked in the chat, does the queue tell us where we stand in line? I wish it did. It doesn't. I think what I'll do is I'll occasionally send messages with the list of where people are. Like I can send a message to the waiting room. I think that will help. I wish Zoom told you where you were in the queue. It doesn't tell you. Alejandra asked, how long do meetings last? It really differs. Some students come in with an A+ paper, and it's like, wow, good job. Keep up the good work, right? And those meetings are usually pretty quick, although invariably the best students want the most time because they ask questions that are, you know how that goes, right? And you come in with a paper that's not very good, and that takes more time. And invariably, the students with the weak papers want to get out as quick as possible. It's this perverse thing where the students that need the most help don't want it. And the students who need the least help want the most. That's just the nature of law school. So, Alejandra, 15 minutes? Could be 5, could be 30, right? It really varies, which is why also the time slots doesn't work. Some students come in and it's a 5-minute meeting, and I'm like, all right, you're doing great. Nothing else to talk about. And I'm sitting there empty for 20 minutes. So it really varies. Some students, it can be an hour. Or maybe I'll say you need to take a follow-up appointment. What I often do for a midterm, and something which I frequently do, is I'll say to the student, all right, this is not your best work. Do it over again. Same exam, just try it again. And come back another time. Students don't actually ever take me up on that. Very rarely. They just disappear, which is unfortunate. So very often after a long meeting, like, we're not close to resolution, do this again. And I give them that chance. And it's their option. They don't have to. But that's a short answer, Alejandra. Any thoughts on the timing, though? I mean, I know a lot of you are night owls because I see your emails. I'm usually up pretty late. I'm usually up till 2 or 3 every night, which makes this 9 in class lovely. But I think if I have evening hours, especially some of you have kids and families, that actually may be better. If you don't want to raise your hand now, you can send me an email, and I'm happy to review your thoughts later. But I want to schedule times when it's going to be meaningful for you all. I don't want to be sitting here by myself. If I am, I'll just turn it off. But if it's meaningful for you, then I'm happy to do it. Yeah, Macy, go ahead.
Would it be optional to make an appointment with you if we are like real time crunchers?
I'll try. Yeah, I mean, I'm not going to say no. I'll try. Everyone's a real time cruncher, though. I mean, basically, everyone has a schedule that's very hard to balance. I think we all do. I mean, some perhaps more than others, but I'll do my best.
Cool.
The other option, which is not ideal, is I could just call you on the phone. In other words, I thought about this option. It's not ideal, but if you give me your phone number, I can just call you when I'm free, which is not always when you're free, right? So in other words, it's trying to line up the two times is very tough, and just thinking about the logistics makes it really hard. But if we can't work something out, then maybe we can just do it by phone, which is less demanding than Zoom. But also, you can't see the screen share. You can't. It's a little bit less personal. But I've never done this before. It's Zoom University. I would be happy if you come to my office, but you can't do it. I mean, the plus side is you don't have to go to the building on a Sunday morning, right? You could just come in your, I don't say pajamas, but you can come on Sunday morning however you are. You don't have to come to school. Yeah, Laney says the queue works. You can do other homework while waiting. Yeah, that's the idea. Just leave it in the background. You'll hear me come on when I come on. I'll have like a 12-hour Zoom call, but that's more or less what I end up doing. Anything else? Okay. All right, let's start then today, our lecture for today. I'll put the link for the class notes in the chat. We are now moving on to the second half of the class. Usually I put the midterm right around the middle of the course, right around the middle. In many law schools, there actually are two separate constitutional courses. You have ConLaw 1 and ConLaw 2. The powers that be at the school decided we don't need that. I would have loved it, but that's not what we have. We have just ConLaw and then a First Amendment class, which I'm teaching in the spring. But ConLaw really has two components in most law schools. The first component is known as maybe structure or powers, right? What are the powers of the government? Does Congress have this power? Does the president have this power? Does the courts have this power? Do the states have this power? What is the structure of the federal government? What is the relationship between the federal and the state governments? What is the structure of the courts, right? The first half of the semester answers all these structural questions, right? How is our government set up? And you may have thought, wow, Josh, this is very wishy-washy. Who knows what commerce is, right? Who knows what necessary means? Who knows what proper means? Just you wait. There's some text in the first half of the semester that gives you some guidance. There's some principles that give you guidance. The second half of the semester takes a very different turn. We're not focused on structure and powers anymore. Instead, we're focused on what you might call rights, liberties, equality. These are cases that are almost all based on the 14th Amendment of the Constitution. Really, the entire rest of the semester with maybe one or two exceptions, is based in the 14th Amendment. Everything. You should give you a new provision of class each week. No, we're stuck with the 14th Amendment for the next, 2 months. And this topic begins with a inflection point in American history, which was the Civil War. Right? This is where this topic comes in, where things sort of changed very much in this country. With the first half of the semester, we talk about the founding in the 1780s. Right? What did Hamilton think? What did Madison think? What did John Marshall think? Right? But the second half of the semester has really a second founding, a different founding. And this was in the 1860s, in the period that came after the Civil War, where in a short period of time, Congress ratified 3 very important amendments to the Constitution. The 13th Amendment, which abolished slavery. The 14th Amendment, which guaranteed certain rights to the freedmen and others. And the 15th Amendment, which guaranteed the right to vote, regardless of your color. So in a very short span of time after the Civil War, there was a constitutional renaissance, a second founding, if you will, a rebirth, where many of the deficiencies in the early Constitution were remedied, at least in part. But in order to get to the post-Civil War period, we need to first walk through what happened before, right? How did we get there? And this topic turns largely on the issue of slavery. This was this issue that was present throughout American history. And it's an ugly history, and I can't make light of it. There's some pretty gruesome stuff going on, and what I want to do, at least from the outset, is to try to think about how the Constitution did and did not reference slavery. And this is a very fascinating history that I don't think is well understood. But I want to walk you through this as best as I can. Randy and I are actually writing a book about slavery and the Constitution, which will not be out until probably after you graduate. But we are working on this. So this is some new material that I'm thinking about, and I'll try it out and you see how it works. A lot of it's already in your book, so you have a lot of it, just for some new stuff, which is we're working on. But I think the first starting point of this topic is the very famous passage from the Declaration of Independence, which I just put into the chat for you all. I'm sure you've read it 100 times, or at least heard it. As I'm sure all of you knew, the Declaration was written by primarily Thomas Jefferson. There were others, John Adams and Ben Franklin, but Jefferson was a primary draftsman. And you have this language there that, really grabs your attention and says, we hold these truths to be self-evident, right? These truths are so obvious we don't have to say them, that all men are created equal. And then it just hits you, just like this ton of bricks, right? Like, how could that statement be written in 1776 when it most certainly wasn't true? There was slavery. Jefferson himself was a prominent slaveholder in Virginia. And usually the way people approach this is to say, well, Jefferson was a hypocrite, therefore we can, this founding document was, a fraud or a myth. And I think that's one way of looking at it. I think there's a different way of looking at this, a little bit more optimistic. When you say something, when you put something in writing, when you assert a principle, you can be judged for failing to abide by that principle. In other words, by laying down this marker, Jefferson and the other founders, they said, here's this really important principle. And then we can say, well, you're not following it. And the response is, well, perhaps you can do it later. What's remarkable about the Declaration is how many people looked at this throughout the generation as saying, here's what we should be doing and that we're not doing now. In the first 6 decades of the Republic, abolitionists looked to the Declaration. They look, this is our founding principle. We should not have slavery. To be consistent with this. Right? People like Frederick Douglass and others look to this as saying, wait a minute, if we believe this, that these are evident truths that men are created equal, how can we have slavery? And it was a rallying call for the abolitionists. So I think there are maybe 2 general ways of looking at this simple passage, which I put for you. One to say that these are a bunch of fraudsters and we can't take it seriously. The second is they made a choice. They didn't have to. They could have just said, we hold these truths to be self-evident that people are created with rights, except for slaves. Right? They could have written that. Right? They could have written that most men are created equal. Right? They could have written that, but they didn't. And I think by writing it this way, they recognized there was this contradiction. And if you study the history of Jefferson and others, it's hard to describe. They understood the evils that they were engaged in. They still did it, right? And I don't want to minimize it, but they acknowledged that what they were doing was wrong. And I think this is something which part of human nature. You can often do something and rationalize, like, well, I need it for my economy. I'll be poor without it, right? Let me just have one more beer. Let me just let me do this bad thing to myself. People do bad things all the time. But they recognized that there was an evil to it. And in the 1770s and 1780s, there was a growing sentiment that slavery was not long for this world. People believed that to varying degrees. Some didn't believe it at all. But there was a growing consensus that slavery was not long for the United States, that eventually it would fade out, that it would end, that it would become no longer economically viable. You can describe it 100 different ways, but there was a growing sentiment that this was not going to endure forever. This was not sustainable. That would change in the 1790s and 1800s through the invention of a piece of technology called the cotton gin. If you ever have seen cotton, it's this very thick, woolly material with these seeds in them, right? And it's actually very hard to clean. You have to take basically a comb and sort of rake the cotton to try and get the seeds out, and that's how they use it to make linen and other things. So cotton was historically not a very valuable crop. But Eli Whitney invented the cotton gin in the late early 1800s. And this invention made cotton a very valuable commodity. So valuable that it basically transformed the slavery debate very quickly. Where it was once looking that slavery was not going to be a useful institution for the long haul, it became one. And with that, this sort of growing sentiment against slavery faded very quickly, at least in the southern states. But this history of the cotton gin happened after the Constitution was ratified. So I want to situate you in the period of the 1780s when the Constitution was ratified. And I want you to all to try to understand some of the controversies that were going on They're going on during this time. So let's start with a poll question, please, and let's try this one. True or false? Oh, any questions so far? I'm sorry, I haven't stopped in a while. I've been talking a lot. All right, let's try a true or false question. This is question number 1. The Constitution of 1787 excluded slaves from citizenship. The Constitution of 1787 excluded slaves from citizenship. True or false? Okay, another 10 seconds. Okay. All right. Now I want you to take a look at question number 2. I want these back to back. The Constitution of 1787 defines who is a citizen. Okay, let's stop you here. All right, so let's take a look at the results in this one. The first question I asked, were slaves excluded from the Constitution? 30% put true, and 70% put false. And the second question, did the Constitution define who was a citizen? 70% said true, 83% said false. Now you see there's a tension here, right? If the Constitution did not define who is a citizen, could it exclude slaves from citizenship? All right. Who's up next? Where am I on the queue?
That's me, Professor. Good morning.
Good morning. Is that Bryce?
Yes, sir.
Okay, Bryce. So, how'd you answer the first one?
I said that it did not exclude slaves from citizenship.
Okay. How do you know that?
Because I didn't see anywhere where it said that the rights afforded were only to people who weren't slaves.
Well, let me ask you a more basic question, Bryce. What does it mean to be a citizen?
To be within a certain boundary and then to be governed by the laws and privileges afforded to people in those boundaries.
How do you know that?
It's just kind of my definition of it, how I thought of it.
So does the Constitution, this is question number 2, Bryce, does the Constitution define who is a citizen?
The one I took for that was Article 4, Section 2.
Okay.
Where it says that the citizens of each state shall be entitled to all privileges and immunities of citizens of the several states.
Okay, it says that. So that says what rights citizens have. Does it define who the citizen is in the first place?
No.
No. Clay, you here? Clay? No. Matt, you here?
Hi, Professor. I'm here.
Okay, good morning. Matt, let me ask you this follow-up question. In Dred Scott, Tony talks a lot about citizenship, right? A lot about citizenship. How do we know who is a citizen under the Constitution? What tells us who is and who is not a citizen?
Well, they spend a lot of time looking to kind of examine the language and the history of the time period to better understand the standing of slaves during the time of the Constitution. And so I suppose the answer is there's not a clear-cut understanding, but there is a lot of extrinsic evidence to suggest that slaves would not be.
Okay, so you're talking extrinsic evidence. You mean stuff outside the Constitution?
Exactly. Sure. Yes.
Can we look to the Constitution itself for evidence of whether slaves are citizens? Can we just look at the Constitution itself?
Sure. The language, as you posted in the chat a few minutes ago, is pretty explicit.
Well, that's a Declaration of Independence. Just be careful here.
I'm sorry.
But I'm asking, can we look in the Constitution for evidence that slaves are or are not citizens? What provisions of the Constitution may shed light on the question I'm asking? Right? There's no citizenship clause. What provision of the Constitution may shed light on whether slaves are citizens or not? There's a couple, at least I can think of 3 really important candidates to answer this question. Jose, you here?
Yes, sir.
So I'm thinking of 3 provisions of the Constitution that may shed light on the question of whether slaves are citizens. What might those provisions be? We've talked about them before.
The Fugitive Slave Act?
The Fugitive Slave Act or Fugitive Slave Clause? Which one did you say?
Right.
Okay. What's the Fugitive Slave Clause?
That like runaway slaves, they should be, brought back to their owner.
All right, so let me bring this up for you all so you can see it. Where is it? Here it is. Okay. All right. So if you go to Article 4, Section 2, we have this provision which says, no person held to service or labor in one state, under the laws thereof, escaping to another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Okay, that's called the Fugitive Slave Clause. Jose, in your own words, what does that mean? Just in plain English.
They have to be brought back to their owner.
Who's they?
Runaway slaves.
Runaway slaves. Where does it say slaves there, Bryce? I'm sorry, Jose. That's two teams behind. Bryce just freaked out. Where does it say slaves there, Jose?
It doesn't, but...
It doesn't? What does it say? What words does it use?
Person held to service or labor.
What does that mean, person held to service or labor? What does that mean, person held to service or labor? What does that mean?
I mean, I think of it, if I see it, I think slaves or indentured servants.
Yeah, but how do you know?
They're held to service, they're like forced, I guess.
Yeah, but how do you know? How do you know what that phrase means?
I mean, history, I learned it before.
But let me, I'm not trying to be difficult, but if they were talking about slaves, right? Why did they just say slaves? Why would they use this sort of other reference as person held to labor or service? Why? I mean, if they talk about slaves, why don't they just say it? You know, make the document clear, right? Why would they just say that?
Because they wanted to include indentured servants as well.
Well, they could have said slaves and indentured servants. They could have said both. Why did they just say that?
I'm assuming because it was what you said, at the beginning of class that they knew this was evil, but they still did it. They wanted,
What's the significance, Jose, just last question to move on. What's the significance of not writing slave here? What's the significance of not putting the word slave in the document? Or Jose, let me ask you the question differently. What if they've written slave in the document? What would that have signaled to the public?
Honestly,
That's okay. Okay, I'll move on. Spencer, you here?
Yes, sir.
Spencer, what would have happened if they had written, if a slave in one state, moves to another state? What would have been the consequence of actually putting the word slave in there?
It would have just been like acknowledging that slavery was okay.
I think you're right, but just explain why. Why would putting the word slave in there have been acknowledging that slavery is okay?
I guess because it's a clause, and we're saying that this is going to be what we're following.
Yeah, let me ask you differently. In the Declaration where we said, where Jefferson said, all men are created equal, right? What's the significance of saying that out loud? What does it mean to say that out loud?
It's acknowledging that this is what we're going to follow going forward for our country.
Okay, so now in the Constitution, what's the significance of not putting the word slavery in there?
It completely undermines what the Declaration was saying. Saying that now we're saying not all men are created equal.
But did they use the word slavery?
No.
Were they acknowledging that's what they were doing? No.
Like, ask me again.
Let's say you were an abolitionist in the early 1800s, right? You were opposed to slavery, and you were having a debate about whether the Constitution approves of slavery. What's one argument you might make about why the Constitution does not approve slavery?
I guess you could argue that first clause that it only was allowing it for 20 years.
No. A much simpler argument, right? You're a lawyer, right? You were a lawyer in the early 1800s, and you're an abolitionist. And you're trying to make an argument that the Constitution does not sanction slavery, does not approve slavery. What's a very good textual argument you can make?
There's no mention of slavery in...
It doesn't mention it. A lot of abolitionists said, look, slavery is not actually authorized by the Constitution because it's not mentioned. Now, Spencer, let's just flip it, right? Let's say hypothetically, the word slavery was throughout the Constitution. You mentioned slavery on every page. Could you make that argument?
No.
No, you cannot. Okay, that's what I was looking for. Thank you very much, Spencer. The decision to write or not write something is significant. And you'll find this when you're, in your practice, right? When you put something down on paper, you're sort of locked in, right? You're locked in, and there are consequences. And at least most of the framers recognize what they're doing is, Shawnee said, super evil, right? I think they kind of got that. Not all of them, and I don't want to pretend this was unanimous, but majority of them recognized that what they're doing was bad. And they were almost, to a degree, embarrassed. And they tried to use, references. So, I forgot what it was. Matthew mentioned the Fugitive Slave Clause, right? And it says, no person held to service or labor. Now, everyone knew this was about slaves, returning runaway slaves. That's what everyone knew this was about. But they didn't need to mention it, because they didn't want to mention it. So we're asking about who's a citizen. Maybe you can look to the Fugitive Slave Clause, but it doesn't necessarily answer the question. Okay? Gracia, you here?
Yes, Professor.
Did I say your name right?
You did.
Oh, good. It's only going to be 2 months. I try. Gracia, let me ask this question, please. What's another provision of the Constitution that you might look to see whether slaves were part of the citizenship. What's another very important clause that might be relevant here?
Well, I was thinking mentioned to the 3/5 clause, maybe.
Yeah, that's a good one. That's a good one to think of. What's going on there?
That was talking about how every slave would be counted as 3/5 of a citizen.
Okay, right? All right, so thank you so much, Gracie. All right, so the 3/5 clause, that was actually the first one I'm thinking of, but we can do it second. That's fair, right? The 3/5 clause was a very important part of the Constitution. And it's important, though, for reasons people don't quite understand. Today, when people talk about the 3/5 clause, they say, wow, the Southerners wanted to count, slaves as only a fraction of a person. And it was actually the opposite. In our Congress, representation is tied to population. The more people you have, the more members of Congress you have. The Southern states actually want to count their slaves as 100%. Right? They want all their slaves to be counted. Why? The South would get more votes in Congress and have more votes in the Electoral College. The northern states were like, whoa. We are not counting your slaves. That'll give you a boost in the Electoral College. We're not counting your slaves. That's ridiculous. These are people who are not held freely. We're not counting them part of your population. So the compromise was the opposite of what people think. Right? It was actually the northern states that didn't want to count the slaves. So the compromise was slaves would be counted as 3/5 for purposes of representation and also taxation. In other words, if the slaves counted toward population, they could also be taxed at 60%. But again, the 3/5 clause doesn't use the phrase slavery. It uses the phrase all other persons. It says they're free persons and all other persons. All other persons, what does that mean? Again, they're using a reference to slavery if that's saying it outright. They could have said slaves, it would have been much more clear, but they didn't say that. All right. Colin, you here? Colin's not here. Ashley here?
Yes, I'm here.
Okay, Ashley. All right, so we did the 3/5 clause. We did the future slave clause. There's a third provision of the Constitution I'm thinking of that may affect the question whether slaves are citizens. What provision am I thinking of?
I'm hoping you're thinking of in Article 5 where it states they can't pass anything regarding the slave trade agreement clause.
Describe the provision, please. That's right, by the way.
Well, it's one of the only ones that's just a big chunk. But I have it that you broke it down that the second part states that 3/4 of the states have agreed that they can't pass any amendments regarding the slave trade.
Okay.
It is for 20 years, I think.
Very good, very good. That's right. Now, I want to just give some background here. Okay? I want to give you some background. Sorry, people. My phone. Okay. The slave trade was a barbaric, gruesome practice. Google some of the drawings and etchings of this, what this looked like. It was awful. People were transplanted across the ocean, chained. They died in large numbers on the voyage. Conditions were deplorable. If you ever go to, there's a civil rights museum in Memphis. If you're in Memphis, I encourage you to go. It's actually, the museum was built on the site of where Martin Luther King was assassinated. They converted a hotel where he was shot. It was a Lorraine Motel. It's in Memphis, into this museum, and they actually have an exhibit where they built a facsimile or like a model of what the hulls of the boat look like, and it's very hard to look at. It's very hard to watch. If you're ever in Memphis, just go there. It's worth your time. But this was a barbaric practice, and even the people in the Constitutional Convention recognized that this practice could not end. That this trade, as it was called, had to be terminated. But they weren't quite ready to eliminate it right away, which is just like another one of these compromises with what they saw as this evil, right? They made a compromise with representation, the Three-Fifths Clause. They made a compromise with the Slave Trade Clause. They said, well, we'll get rid of it later, but we can't get rid of it until 1808. Indeed, fast forward to 1808, it was eliminated. One of the first, basically as soon as 1808 rolled around, that was one of the first actions that were taken. But even still, with the Fugitive Slave Clause, they don't use the magic words, right? They don't say slave, right? It says such persons. The migration or importation of such persons should not be prohibited by Congress before 1808. This is in Article 1, Section 9. So again, they say such persons, right? So it's other persons, such persons, persons held to service or labor. It's, almost like they're trying to say the opposite of what they're saying, right? They don't want to acknowledge it. And I think that this moment in time, the 1780s, was this sort of unique period where there was a growing recognition that this was not something they should be doing. It would change later. I don't want to minimize that, but in this period, there was this sort of like a naivete, if I want to use that word, just this optimism that things would just work out. And it didn't. But the decision to put the slave trade is in Article 1, Section 9. It's also referenced in Article 5. It's actually referenced in two places. Article 1, Section 9 says Congress can't enact a statute to ban it. And Article 5 says you can't amend the Constitution to ban it before 1808. It's a fun question of whether Congress can limit an amendment the Constitution can limit an amendment. Can you have an unconstitutional amendment? But at least in this period, there was just sort of a hope that things could be worked out, that this would end. All right, so I haven't said anything about American history yet. Just talk about the Constitution's text. Any question about these three provisions, the Three-Fifths Clause, the Fugitive Slave Clause, and the Slave Trade Clause? Anything? Where is the Three-Fifths Clause? It's in Article 1. Where is it? Oh, God, I don't have the citation handy. Just give me a second, Lane. I'll find it. Article 1, Section 2. Thank you, Macy. Thank you so much. Now, you should all know that none of these provisions are valid anymore. The fugitive slave trade clause expired on its own by 1808, so that was long gone. The 3/5 clause and the fugitive slave clause were wiped out. I think the fugitive slave clause was wiped out by the 13th Amendment, which eliminated slavery. And the 3/5 clause was wiped out by the 14th Amendment. They don't say so expressly, but it's understood that you can't have a clause about runaway slaves if you can't have slaves. And the 14th Amendment specifically just defined how populations are apportioned, which is equality. Everyone's a citizen. So there are no more other persons. So those two provisions were wiped out by the 13th and 14th Amendments in the 1860s. All right. Everyone with me? Any questions so far? Good? Okay. Thank you. All right. So let's move on from the sort of optimistic naivete to things got worse. I can't stress enough how important the cotton gin was. It sounds stupid, but a piece of technology truly and honestly affected American history in ways that are not, I think, fully appreciated. As slavery became a more valuable commodity, politics shifted. An ideology began to form in the American South that slavery wasn't just an economic necessity. A pro-slavery ideology formed that slavery was actually just, that it was good, that it was righteous. The perception was that it was inevitable, that there was this inequality of the races, and that people of African descent were destined for service. Let me try to explain this as best as I can. When you're doing something that's wrong, you have to convince yourself that what you're doing is actually just and moral, right? In any civilization or any society, anyone, when you do something that's wrong, you have this little voice in the back of your head saying, what are you doing? This is not right. Don't do this. This is bad, right? We all have that voice. And we learn to shut that voice up. We all do it in our own lives, right? It's like, no, don't do that. Don't do that. Okay, I'll do it. And in the southern states, this sort of ideology emerged that helped shut up that little voice. And the ideology was that slavery was a just institution and that the destiny, the fate of black people was for service. As this ideology developed, the politics embraced it. And Southern politicians began to see their primary mission in Congress was to preserve slavery. It wasn't so monolithic. Even at the convention, the Virginia delegations were somewhat uneasy about the slavery compromises, but within a certain number of years, that just faded. And the slavery ideology was so distinct that they wanted it to spread nationwide. They didn't want it to just be limited to their states. They wanted every state to have it. Because if this is something that's moral and just, then every state should have it. How did this manifest in the young republic? With the expansion of new states, every new state that was added to the map was a territory first. And there were vicious, vigorous, bloody debates over whether a new state would become free, or called free soil, or whether a new state would become slave, right? Because every new state that was added to the map would either send members of Congress who were slave or anti-slavery, right? Today it's a politics is different. We think of a state as Republican or Democrat, right? Right, those are the two divides, and it's more or less geographically sort of north-south, but not perfectly. But in this time, it was slave versus no slave. That was a sort of divide. It wasn't by party so much as it was by ideology. But of course, there were political parties as well. There was a slavery party, an anti-slavery party, but that was a dividing issue. And Congress had many fights over whether slavery was to be expanded. So, for example, the District of Columbia, D.C., the nation's capital, permitted slavery. Why? Because the slave states dominated the federal government. Almost all the early presidents were either slaveholders, or they were in favor of slavery, or they didn't actively oppose it. They were sort of okay with just preserving the status quo. So D.C. maintained slavery. And eventually Congress reached a deal about the territories, right? And that deal was known as the Missouri Compromise, right? The Missouri Compromise. The Missouri Compromise was a very important piece of legislation. Okay? What it tried to do was divide the map in half. And it said, any state or territory north of a certain line would become free. And any state south of that line would become slave. And this was a compromise that the United States hoped would not resolve the slavery issue, but sort of delay just delay the conflict. But it wasn't very good compromise, because people were still fighting about which would be slave and which would be free. All right. Laney asks, why do they let each state decide for itself? How would a state decide? You had people flooding the states to vote one way or the other. In fact, in some states you actually had that, where people would move in there just to keep it as slave or free. So Congress tried to settle the issue, although it was it was not a very good compromise. Yeah, Moses says that Kansas, Nebraska, there were bloody fights on borders over whether a state was going to be free or slave. This was not something that was done lightly. Okay. All right. So the the Missouri Compromise was this sort of deal that was designed to avert these crises. But the Missouri Compromise didn't address the situation of what happens when a slave moves from one state to another. There was a famous decision called the Summerset Case. I know I'm lecturing a lot, but there's just some background I have to give you. I'm sorry. The Summerset Case, Somerset, the Summerset Case. It was an English case from 1772. And the Summerset Case was an important decision. It said that slavery could not exist in England. Right? Slavery could not exist in England. So if a slave was brought from, I think it was Jamaica, to England, Jamaica was an English territory at the time, the slave will become free as soon as he enters England. The idea was if you breathe English air, or you step on English soil, right? It's this beautiful imagery, right? You take a breath of fresh, free air, you're free, right? This was this concept from the Summerset Case, that slavery could only exist if the government authorized it, right? If the government authorized slavery, then you could have it. But England had not authorized it. Okay, so now if we sort of transplant the Summerset case to the United States, that means if a slave travels from, say, Georgia to Massachusetts, Massachusetts doesn't have positive law. Therefore, the slave will become emancipated. Free. When I say emancipated, I mean free. That's what emancipated means. But what about the Fugitive Slave Clause? Right? That specifically says if a person held to service travels from a slave state to a free state, they got to be returned. The Fugitive Slave Clause was designed to address the Summerset case and explain, no, you do not become free. Right? So there's a clause in the Constitution that says you don't become free. But what happens? What happens if a state decides to grant citizenship to a runaway slave and not assist in his return? Well, again, Congress intervened and passed a law saying that was illegal, that the states could not help the runaway slaves. And that history, this long, winding history, brings us to Dred Scott. Dred Scott was a decision that had a very significant impact in American history. It's hard to describe how big that impact was, but it's a huge impact in American history. But the issue at play was actually fairly narrow. Right? All right, let's see. Who are we up to? Lauren, you here?
Yes, I'm here.
All right, Lauren, help us out, please. Let's just start with the facts in Dred Scott, and then we'll get to the the messy stuff that Tawny does. Let's start with the facts, please.
So Scott was a slave owned by, I think, Emerson, and he took him to a free state. Well, he took him around a bunch, like between free and then other free states and territories. And eventually, when he died, Scott was left to his wife, who left her assets and stuff to deal for her brother to deal with.
Mm-hmm.
And that's when the lawsuits started, because Mr. Sandford didn't want to pay back the wages that were owed to Scott.
Okay, very good.
So,
go on, please. Please, you're on a roll.
So then he sued for his freedom and was actually granted freedom, but then the Missouri Supreme Court overruled it and overturned their own precedent to do so. And so then he filed the case that we are looking at to sue in federal court under diversity jurisdiction.
Okay, excellent. Okay, very good. Okay, I think very good. That's what I needed. Okay. All right, so let me give you some background. At the time, the Summerset case was significant. A number of state courts began to hold that if a slave enters a free territory or enters a free state, they breathe free air, right? They step on free soil. These sort of beautiful images become emancipated. Missouri had been one of those states. So the thinking was, if you brought a slave to a free state, you did so at your own peril, because the slave could then go to a court in that state and seek emancipation. And a number of courts are starting to hold that. That was the case with a man named Dred Scott. He had a remarkable life. Someone who was thrust into this national spotlight just unexpectedly. But Dred and his wife Harriet were both slaves. And they were owned by a doctor named Emerson. They had 2 kids. One was born in free territory. The other was actually born on the Mississippi River. My goodness, can you imagine giving labor on a riverboat? I just can't fathom that. By the way, did you see a woman in Illinois went into labor during the bar exam? She was taking the bar, and listen to me, she was taking the bar online, because I think it was in Illinois, you take it on your computer. She had planned to take it in July when she was, 5 months pregnant. But instead, because of the delay, she took it in October when she was 9 months pregnant. She went to labor during the bar. But the bar has this stalking software which monitors you. And if she were to have gotten up, she would have been marked for cheating. So she sat there while she was having contractions and finished the exam. She went to the hospital and gave birth. And then the next day she resumed taking her exam. Who is this woman? I've now seen 2 childbirths. I don't understand how it's humanly possible, but that's remarkable. Yeah, I hope she passed, right? I hope she did. She didn't give her let her pass anyway. Yeah. So the Harriet Scott gave birth on a riverboat in Mississippi. That sounds awful. Her kids will never hear the end of it. Okay. Her law firm partners better give her a nice bonus for that one. Worth it, right? So there were 2 kids, and as the history goes, it was apparently Harriet that really pushed her husband to file this lawsuit. He apparently wasn't so keen on it, but anyway, she was the one who was like, do it, because she couldn't do it herself because the women were even in a worse stead than the men were. Initially, Dred Scott sued Sandford, who was the new owner, in state court. And it was a straightforward emancipation case. Under the controlling precedent at the time, under Missouri law, Scott should have been emancipated. He traveled to the free state, free territory. But the Supreme Court of Missouri reversed its precedent, which they can do, they're allowed to. And they said, no, we don't do that anymore. Okay, so at that point, what does Scott do? He could have appealed to the U.S. Supreme Court. For reasons that are not entirely clear, he didn't. I think he wants to be in federal court. There are lots of reasons why, but it's not entirely clear. But he never appealed his judgment to the Supreme Court. He then filed the exact same lawsuit in federal court. Now someone says, Josh, what about res judicata, right? Yeah, it's not a bad argument, right? He was basically barred. I think he was barred from bringing the lawsuit. Generally, if you lose in state court, and just putting aside the case, if you lose a case in state court on the merits, you can't just go make the exact same lawsuit in federal court. There's res judicata, right? You're stopped. But that is not CIFRA, I'm sorry. So then he goes to federal court and he sues in diversity jurisdiction. Now you all studied in your civil procedure class 28 U.S.C. was it 1332 or 1331? I'm sorry, 1331, which is the diversity jurisdiction statute, right? Oh, sorry, no, I was right the first time. 1332. Sorry, 28 U.S.C. 1332 diversity jurisdiction statute. That's actually premised on a provision of the Constitution, right? Article 3 says, I'll put in your chat right over here. Article 3 says that the judicial power extends to a controversy between citizens of different states. Right? That's right in the Constitution. But the Constitution does not define who is a citizen. This was my question to you at the outset of class. Right? The Constitution is silent about who is a citizen. It just doesn't say. Excuse me. Historically, citizenship was not defined by the federal government. Citizenship was defined by the states. Right? There really wasn't a conception of federal citizenship. Perhaps for immigrants who were coming here, but generally, people born here were defined by their states as citizens. And many of the northern states granted citizenship to free blacks. Both people who were born free and those who were emancipated. So in some states, if you stepped foot on free soil, you took a breath of fresh air or free air, you were deemed a free citizen. And you got paperwork and everything. They're called your emancipation papers. You had your papers. So Scott says, look, I am a citizen of Missouri, and I'm suing Sandford, who is a citizen of New York. So the Dred Scott case wasn't actually about whether Scott was emancipated, the issue turned on something as mundane and boring as federal jurisdiction. Can you imagine? Right? Did you ever think the Dred Scott case was about civil procedure? Like, you've all heard of it, right? Did you think it was actually about 1332? Could you imagine, right, that this entire freaking case is about who is a citizen of which state? It seems like so, like, I don't want to say boring, but like just not what you were expecting. All right? So, it's Lauren. Who's next? Aaron, you here? Okay, so Aaron, I'm sorry?
I said hi, yes, I'm here.
Hi. Hello.
Sorry.
Hello. So, Aaron, let me ask you a question, please. Let's cut to the chase. Was Scott deemed a citizen of Missouri? Just cut to the chase.
By Missouri?
No, but by the Supreme Court, by Justice Taney.
Oh, no.
Okay. So let's just handle hypothetical for a second, Aaron. Generally speaking, if Scott was not a citizen, did the court have diversity jurisdiction?
No.
Okay. Generally speaking, if a court lacks diversity jurisdiction, what is the proper remedy, or what's the proper way to dispose of the case?
Taking it back to state court.
But what happens to the federal case?
It's dismissed.
And how long will that opinion be? If, let's just say I sue you, I'm a Texas citizen, you're a Texas citizen, I sue you in federal court in Texas, right? I'm an idiot. What happens to that lawsuit?
It's dismissed.
How quickly is it dismissed?
Pretty quick.
If you were the law clerk writing the opinion, how much space would you need to dismiss that case?
Like a paragraph.
A paragraph. See where I'm going with this, right?
Mm-hmm.
Why did Chief Justice Taney write? I mean, it's 20-something pages in your book, but the opinion's, I think, over 100 pages in the original. It's maybe even longer, I can't remember. Why did Chief Justice Taney, Aaron, write all of this stuff on, like, every conceivable issue you can imagine about slavery? If the simple disposition was no jurisdiction, dismiss, go back to state court, right? Why did he do all this stuff? That's my question for you.
I guess just to address the issue of slavery and basically say that slaves are not citizens. Generally.
You're right, but why? I mean, that's why he did, but why did he do all this stuff?
I guess because it was such a controversial issue at the time.
Yeah, no, that's true. But why did he feel the need to address this controversial issue? I feel like I'm a kid. Why, right?
Sorry, I'm not sure.
No, that's okay. Let me try a different way. Why do you think Taney felt compelled to address this issue? What do you think he was trying to do there?
I mean, he was trying to make the Missouri Compromise unconstitutional. He wanted to prove that. So that's probably why he went through the entire issue of whether or not Scott's a citizen, because then he addressed the Missouri Compromise.
Okay, I'm beating up an Aaron, but I think you did a good job. Okay, thank you. All right, thank you, Aaron, for that. I appreciate it. Chief Justice Taney thought that he could resolve this issue. He was of the mindset that the Supreme Court had this sort of authority to adjudicate national controversies. And one of those controversies was slavery. Laney asked, was this legislating from the bench? I don't know what that means, but if it means anything, it's this. Taney thought that he could write an opinion that would settle the dispute. In one regard, he recognized the issue. I think he recognized the issue correctly. That this sort of uneasy truce between North and South could not endure. right? This Missouri Compromise, which was 30 years old, was not holding up. That there was blood, there was bloody violence in the frontier, and Tawney saw that the nation was headed towards a schism, a fracture. And I think on that part he was probably, and we know he's right. Where he went very wrong was how to address it. His decision probably hurried up. It sped this civil war. It didn't delay it. But I think Tawney's recognition explains why he did what he did. Had he just dismissed this case for lack of subject matter jurisdiction, it would have gone away. But Tawney realized there would be some other case, right? Maybe there'll be an appeal from a Supreme Court of a state, in which case there's not any jurisdictional issue, right? If there's an appeal from a Supreme Court of a state, you don't have to worry about federal diversity jurisdiction. And basically, Tawney didn't want to wait. He's like, you know what? Screw it. Let's cut to the chase. Can you imagine, right? You just skip over jurisdiction to get to this really significant issue. So he wanted to resolve it. And he resolved the issue in quite possibly the worst way imaginable. Who's next? James, you here?
Yes. Hello.
Hey, James, how you doing? James, let me ask you a question, right? Let's say that Tawney wants to write a narrow opinion, right? What could he have written to maybe resolve this case narrowly? Maybe just how could he have done this a little bit more, cautiously?
I guess he could say that Congress has the power to the Uniform Rule of Naturalization, and at this current juncture, based on, I guess, history, Scott is not a citizen.
Okay, that's actually good. He could have said that based on this history, Scott is not a citizen, but that maybe at some point in the future, Congress could do stuff to make him a citizen, right? Is that your point, James? Okay.
Exactly, yes.
Does Tawney do that?
Absolutely not.
No. Does he say that Scott could ever become a citizen?
No, he never says he can become one. He expressly says that he cannot become one.
Exactly. He does the opposite. Why can Scott never, ever, 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 ever become a citizen in Tawney's mind?
Because at the time of the founding, the founders never once thought that blacks were equal to whites, and therefore they can never become a citizen.
Okay, James, let me ask you a follow-up, please. Why did Tawney go out of his way to say that people of African descent could never, ever, 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 ever become citizens, no matter what happens? Congress can't make him a citizen. The states can't make him a citizen. He uses this awful language. I mean, just unfortunate race, right? I mean, he uses these words, inferior order, just this supremacist language is another way to describe it. Why does he go out of his way to call these people ordinary articles of commerce, right? Of traffic, merchandise. Why does he go out of his way to do all these things? He believed it, put that aside, but why does he put this in an opinion?
Just in my own personal view, so that he can make his argument about the property argument later?
That's actually very good. Not what I was looking for. That's a good answer. But what does this do to Congress in the future? Could Congress ever come back and try to correct this in Tawney's mind?
No.
No, they can't.
He said this is the
Yeah.
way the founders thought, and we're stuck with it.
Yeah, okay, very good. Thank you, James. I'll come back to your second point in a few moments. Tawney was trying to settle this issue, and I don't use the word settle lightly. He was trying to make it abundantly clear to the entire country that these people are, by their very nature, inferior. They're the unfortunate race. Fixed. There's no changing it. So if Illinois or Massachusetts or New Hampshire decides to grant citizenship to a slave, that cannot be actual citizenship. They may call it citizenship, but it's not real. Why? Because these are an unfortunate race. They can't have it. He was trying to address a future Congress that purported to grant slave citizenship. Let me say that one more time. Tawney recognized at some point in the future a Congress may try to grant citizenship to a slave. And what he's saying is, no, you can't do that. You can't do it at all. Right? But there's a second reason why he does this argument. They make them describing as, articles of chattel, property, commerce, right? Merchandise. Same way if you're transporting widgets. The Fifth Amendment Due Process Clause provides that the government cannot deprive a person of life, liberty, or property without due process of law. Right? Again, I'll just put it in the chat. Okay? A person cannot be deprived of life, liberty, or property without due process of law. Now, who am I up to? James. Bianca, you here?
Yes, I'm here.
Bianca, so if you were a lawyer, you were an abolitionist, right, in the 1800s, you're a lawyer for the slaves, and you look at the Fifth Amendment, how would you read that to try to help the slave? You just read the text of the Fifth Amendment. What argument would you make just looking at the text of the Fifth Amendment? You're the lawyer for a slave. You're trying to get your client emancipated. What might you look to? What is slavery doing to people?
What is slavery doing?
Yeah,
What is it doing to the slaves?
Yeah, that's what I'm asking. Yeah.
It's making them just like property. Like
No.
It's dehumanizing.
You use the language of the Fifth Amendment. What's it doing to them? What does slavery do to a person? It what?
It, I guess, like holds them against
Read
their
the Fifth Amendment. I put it in the chat.
Okay, no person shall be held to answer for a capital or otherwise infamous crime.
Okay.
On a presentment or indictment of a grand jury.
Okay, go down further towards the end, where it says be deprived.
Be deprived of life, liberty, or property.
Okay, stop right there. So it says no person should be deprived of life, liberty, or property, right?
Mm-hmm.
What is slavery doing?
It's making them property.
No. Well, yes, but what is slavery doing to their liberty?
Oh, it's taking it away.
What word's being used in it? Just use the word in the provision.
Deprived.
Thank you.
Deprived
Okay.
of liberty. There we go.
Okay, try it again. So what is slavery doing to these people?
It's depriving them of their liberty.
Okay. So Bianca, the flip side is, would Tawney say that the Fifth Amendment protects the liberty of a slave?
No.
Why not?
Because...
Who does the Fifth Amendment apply to? What's the first two words in the amendment?
No person. Oh, because they're not considered
Bingo.
people.
Bingo. That's it. Very good. I know I'd get there. I knew it would take me a minute, but I got there. Thank you, Bianca. That's exactly right. It's a very cute puppy, by the way. Okay. Tawney has to go out of his way to dehumanize the slaves to address the counter-argument that the Fifth Amendment deprives them of their liberty. But if they're not people, they don't have liberty. Right? He has to do these very specific moves, and I don't have a better way to describe these very specific arguments he has to make to basically preempt arguments that were made down the road. Again, the Dred Scott case was not a huge case. This was a guy from Missouri, right? This wasn't this national test case on slavery. It was just a single person. But Tawney was trying to, sometimes when you're writing a brief, you anticipate the arguments your opponent will make, even if they haven't made them yet. It's a good tactic, right? Tawney was a lawyer who was trying to anticipate what his arguments would make in the future. And you say, look, these people are not property. So they're not persons, they're slaves. Therefore, they have no liberty to be deprived. Right? But the Fifth Amendment has this other word, which Bianca kept trying to go to and kept telling me, no, not yet, which is property. If the slaves were not people and they were property owned by someone, which is by the slave owner. And the same due process clause says that a person, slaveholder, cannot be deprived of his property, the slave, without due process of law. So Tawney latched onto this argument that the Missouri Compromise deprived Emerson of his property without the due process of law. That is, it was a random and arbitrary law that said as soon as you step foot on the soil, you lose your slave. Well, that's no process. That's not fair. I didn't consent to that. And Tawney argues that this law deprives them of their property without any sort of process, without any sort of fairness. So it's this sort of bizarre world where slaves are being held against their will, but they're not being deprived of their liberty. But the person holding their slave does have a constitutional right to hold the slave. In other words, there's no right for the slave to be free from oppression by the state. But the state protects the slave owner from holding the slave. Right? Do you see the sort of interlay, right? That the same provision of the Fifth Amendment, the Due Process Clause, simultaneously protects the slave owner, but does not protect the slave. The Due Process Clause protects a slave owner's property interest, but does not protect the liberty of the slave himself. So it's this sort of, when I mentioned this pro-slavery ideology, Tawney didn't make this up. He didn't make it up. These are arguments that were developed over the last 20 years. And these arguments developed in response to arguments by the abolitionists, right? The abolitionists like Frederick Douglass and others said, wait a minute, we're people. You can't deprive us of our liberty. It's in the Fifth Amendment. And then the slavery people said, no, you're not people. You're just property. You're chattel. And by the way, because you're chattel, your masters have a right to you that can't be taken away by the government. You see, when we say the phrase chattel slavery, you've heard this before, but it was actually a constitutional argument, right? The reason why they were analogized to chattel was not just to dehumanize them in the abstract. It was a legal argument. It was a legal argument to situate the case within the context of the Fifth Amendment, right? Every major dispute in American history had a constitutional element. That's just our history. Right? I can't tell you the story of American history without telling you the story of constitutional law. That's why this class is so history-oriented. The entire notion of this chattel slavery became so prominent in the United States because it helped them with the Fifth Amendment argument. Right? That's the sort of dehumanization was grafted onto the text of the Fifth Amendment, and that's sort of where this came from. It didn't develop independently; just sort of these arguments merged together over time, and then Tawney sort of crystallizes them together and puts it all into one package. It's easy to digest, right? And let me summarize Dred Scott just a little bit. It was a remarkable case. I don't mean remarkable in a good sense. It was a terrible case. It's one which is what's called the anti-canon. Remember I said Korematsu? It's you should not be signing Korematsu under any circumstances. There was actually a case a couple of years ago where I think it was a Missouri Attorney General, maybe it was Kansas, cited Dred Scott in a brief. And it was such a backlash I had to actually withdraw the brief and refile it. It wasn't even a necessary citation. It was about Tawney said in Dred Scott that here was what it was. Tawney said in Dred Scott that the Declaration of Independence should not affect how we read the Constitution. Yeah, no kidding, right? The Declaration says all men are created equal. Tawney says, no, that doesn't count. We don't read the Declaration. So there was some case about whether the Declaration should be read to interpret the Constitution. Said, no, we don't read the Declaration. Go see Dred Scott. And it was like, no! So there was this backlash, and they had to withdraw the brief. It was ugly. I think it was a Kansas, maybe Oklahoma AG. I can't remember which one it was. But anyway, there it was. All right, so let me try to summarize Dred Scott just a little bit, because there's so many moving parts in this case, right? So the first holding was that Scott was not a citizen of any state, because people of African descent cannot be citizens. Tawney was wrong about this, flat out. At the time of the founding, a number of states granted free blacks the right to be citizens. It's just historical fact. In a number of states, free blacks could vote. So Tawney's history is just wrong. It wasn't a majority of the states, but there were some states. So I don't think he can make these sort of sweeping generalizations. Okay, so if the case lacked jurisdiction, they should have dismissed everything. But Tawney did not. He then resolved a very important constitutional question. Was Scott emancipated when his owner brought him north to the Free Territory? Tawney wanted to resolve this issue, and Tawney held no. That the Missouri Compromise was itself a violation of the Fifth Amendment. That the Missouri Compromise deprived people of their property without the due process of law. Right? Therefore, the Missouri Compromise was unconstitutional. This is a very significant holding. Okay. There's a lot more in Dred Scott. I've only given you actually a small portion, but there was so many moving parts. There were 2 dissents in Justice Tawney's opinion. The vote was only 7-2. They asked, Josh, how is it only 7-2? It wasn't 5-4. At this time, most of the presidents were Southerners, and they were pro-slavery. It's unsurprising that pro-slavery presidents would appoint pro-slavery justices. That's why the bench was so stacked. There were 2 dissents by Justice Curtis and Justice McLean. I think these dissents are important to show that that even at the time people realized how awful this was, right, how bad this was. In fact, Justice Curtis resigned from the Supreme Court because of Dred Scott. He was so pissed. He was livid at Tawney that he resigned. He said, I can't do this anymore. I can't work with this person. And he stepped down from the court. All right. Questions on the Dred Scott opinion. It's just so many things. I could spend an entire semester on this case if I had to. Questions on Dred Scott? Yeah, Tori, go ahead.
So, because they technically didn't have jurisdiction, I'm trying to resolve, is the opinion just all dictated?
I knew you were going to ask that. I love that question. I get that every year. Well, let me frame the question a little differently, Tori. Who was this lawsuit between? Who were the 2 parties?
Scott and Sandford.
Okay. So between Scott and Sandford, was there a judgment? Was there a ruling for them?
In the federal court?
Yeah. In other words, Scott sued Sandford to get his freedom, right? Did he get his freedom?
No.
Okay. Right. So in that sense, it doesn't really matter what the opinion says. The bottom line is Dred Scott was still a slave owned by Sandford, right, Tori? Okay. Now, Tori, Tawney went beyond that and he declared the Missouri Compromise unconstitutional. And he did this in what you call a dicta. Was the federal government a party to this case?
No.
Okay, Tori, let me ask you a harder question. Is the federal government bound by Dred Scott?
I would assume not.
Why would you assume not? Can we just ignore Supreme Court cases we're not part of? Why not? I don't know. Ooh. You're struggling. I know you are. I struggle
I
with this.
understand, the Supreme Court is interpreting laws, but they didn't. Why is it even being brought up in this case? You know what I mean? I get it, but also you can't just throw in whatever you want and have an opinion on that, right? Oh,
Let me give some background to Tori's question. It's a very good question. I usually get it in different ways, but I'm glad she asked it that way. Scots know what they want. Yeah, no, they can't. So at the time that Dred Scott was decided, there was a young lawyer rising to prominence in Illinois. His name was Abraham Lincoln. You maybe heard of him. Very, very prominent lawyer. And his rise to prominence was based on attacking the Dred Scott decision. Right? But he made a very specific argument that law students love here. They don't like it in other cases, but they love it here. I think this goes to Tori's question. Lincoln said, look, this decision was freaking ridiculous, right? There was no jurisdiction. What the hell are you doing, Tawny, right? There's no jurisdiction. You can't go declare federal law unconstitutional in a case brought between two people. Right? You can't do that. That's nuts. So Tawny said like this. He's like, look, this was a lawsuit between Dred Scott and Sandford. They're bound by it. Those two are stuck by this judgment. But the federal government was not a party to the case. They weren't. So the federal government was not obligated to follow the decision. So when President Lincoln was elected, did he stop enforcing the Fugitive Slave Act? I'm sorry, the Missouri Compromise? No, he followed it. When Lincoln was president, did he stop granting citizenship to free blacks? No, he did. He granted passports to blacks to travel. Lincoln's Secretary of War admitted runaway slaves into the military and granted them citizenship. Right? If a runaway slave made it to the Union Army, they became citizens, so did their families. Dred Scott said you can't do any of that stuff. Now, did the Supreme Court get ignored here? Or did Lincoln just say, yeah, that's not us. This was not our dispute. We're not bound by it. I see Tori smiling, right? Can Lincoln do that? And let me just immediately... I'm sorry, Lane, you're right. I meant Lincoln. Lincoln said, we're not going to follow it because it's not our binding judgment. Now, students like, oh, yeah, that's so smart, Lincoln. You're a badass, right? Go Lincoln, right? Yeah, guess what happened after Brown v. Board of Education? Segregationists did the same thing. They said, well, Brown versus Board of Education of Kansas. Well, I'm Arkansas. I'm not Kansas. I'm not bound by that judgment. And the sort of dragged out game went on for years as Southern jurisdictions resisted Brown v. Board. So, you love when you're resisting Dred Scott, not so much when you're resisting Brown. It's just conflict where I get you, oh yeah, that's awesome, Josh, right? That's so cool. Oh, wait a minute, right? So it's tricky. But Lincoln said, this decision's ridiculous. We're not bound by this. We're not going to do it anymore. All right. After Dred Scott, Lincoln rose even more to national prominence, and he was elected to president in 1860. By the time he was elected, a number of Lincoln's views were very complicated. Dr. Steiner is he's an expert on this. Lincoln's views were not simple. No one's views are simple and straightforward. These were complex people, very complex people. I don't pretend to know them well enough. But Lincoln at least was consistent on Dred Scott, which I can tell you about. By 1860, a number of states had already seceded. And when Lincoln took his inaugural address from Tawney, the Civil War basically blew up. And then Lincoln began the Civil War. And we'll talk about that more in next class. I don't have time to do it now. But the Dred Scott decision, in many ways, brought a civil war closer, made it happen quicker than might otherwise have happened. Okay. All right. Questions on the Dred Scott case. Really important case. I could really teach an entire semester on it. Questions on Dred Scott? No? Okay. All right. Well, start the minute poll now. I'll be back to office hours around 12:30. Thank you all. Have a wonderful day.